Imagine you have taken time off work to care for a family member or recover from a serious health condition. You followed all the rules, but when you tried to return to your job, something felt wrong, as if your rights were not respected. If you believe your Family and Medical Leave Act, or FMLA, rights have been violated, the primary place to file a complaint is with the United States Department of Labor's Wage and Hour Division. The Wage and Hour Division, often referred to as the WHD, is the federal agency specifically tasked with enforcing the FMLA. They investigate complaints from employees who believe their employer has denied them eligible leave, retaliated against them for taking leave, or failed to reinstate them to their equivalent position. This division has the authority to investigate your claims, mediate disputes between employees and employers, and even pursue legal action against employers if violations are found. Their crucial role is to ensure compliance with the law and to protect the job security and health benefits of workers who need FMLA leave. First, gather all relevant documents that support your claim. This includes your FMLA request forms, any communication with your employer about your leave, medical certifications, return to work notices, and documentation of any adverse actions taken against you after your leave, such as a demotion or termination. Next, visit the Department of Labor's website or call their toll-free number to locate your nearest Wage and Hour Division office. They have offices located across the country, making it accessible for many individuals. You can then schedule an appointment or simply walk in during business hours to speak with an investigator who can help you initiate the complaint process. When you file a complaint, you will need to provide specific details about your employer, the nature of the alleged FMLA violation, and the precise dates involved. Be prepared to explain clearly what happened and how you believe your FMLA rights were infringed upon, as having a concise timeline of events is very helpful. The WHD generally has a 2-year statute of limitations for filing FMLA complaints, so it is important to act promptly after you suspect a violation has occurred to preserve your rights. It is worth noting that while the Department of Labor handles the vast majority of FMLA complaints, you also have the option to pursue a private lawsuit in court. This is usually done with the assistance of an employment law attorney who specializes in worker protection. A private lawsuit can allow for recovery of damages such as lost wages, benefits, and potentially even liquidated damages if the violation was determined to be willful by the court. The choice between filing with the WHD or initiating a private lawsuit often depends on the specific circumstances of your case, the complexity of the situation, and your desired outcome. The WHD process is typically free and less formal, providing a direct route for resolution, while a private lawsuit can be more complex and potentially costly, though it may offer broader relief and greater control over the legal process. Understanding exactly where to turn when your FMLA rights are compromised empowers you to protect your job security and your ability to care for yourself and your loved ones during critical times. By taking structured and informed steps, whether through the Department of Labor or through a private legal action, you help ensure that the vital protections afforded by the Family and Medical Leave Act are upheld, allowing you to focus on what truly matters most during challenging life events.